I want to start today by telling you about something that most seniors have never been told, and that the IRS does not advertise. You are allowed to challenge an IRS penalty. You are allowed to request a free personal advocate when the IRS system fails to resolve your issue. You are allowed to pull your own tax account transcripts and read them. And you are allowed to file for a refund or abatement of a penalty you believe was assessed in error, without hiring an attorney, without paying a fee, using a form that is free to download from the IRS website. I am going to give you all three of these tools today in plain English. But first, I want to acknowledge something honestly. There was a specific refund opportunity tied to COVID-era tax penalties that a court case created, a window to file a protective claim by July 10th, 2026. That deadline has already passed as of when I am recording this video. If you saw content about that opportunity and are wondering whether you can still act on it, the honest answer is that the specific deadline window has closed. But here is what has not closed and will not close: the permanent tools I am about to describe. They were available before that case. They are available now. And every senior who has ever received an IRS penalty notice and simply paid it or ignored it deserved to know they existed. I'm Anderson. I spent 5 years as a financial advisor in New York, working with families through retirement planning, Social Security decisions, and the moments when a government system created a problem that required someone to navigate it carefully. What I have is 5 years of watching people accept outcomes from institutions they assumed were final and beyond challenge, when the tools to challenge them had been available all along. Subscribe and hit the bell, because when the IRS or any other government agency changes rules that affect your tax situation, I will explain what those changes mean and what you are allowed to do about them. Now let me walk you through the three tools. The first tool is one of the least known and most powerful resources available to any American taxpayer, and most people, including most financially literate people, have never heard of it. Inside the Internal Revenue Service, there is an independent office called the Taxpayer Advocate Service. Its job is specifically to help taxpayers when the normal IRS system has broken down and to flag when the IRS itself is getting something wrong. The person who runs this office, the National Taxpayer Advocate, reports directly to Congress by law. The IRS cannot edit or filter what the National Taxpayer Advocate says. That independence is what allows this office to issue reports that sometimes criticize the IRS's own practices and flag relief opportunities that the IRS is not proactively offering to taxpayers. This office does 4 things that every senior in a difficult IRS situation should know about. It handles individual cases. If you are facing a tax problem that the normal IRS process has not resolved after 30 days, or that is causing you genuine financial hardship, you can request a personal case advocate through the Taxpayer Advocate Service. That advocate is assigned specifically to your case and stays with it until the issue is resolved. The service is free. There are no income limits on eligibility. The second thing the TAS does is identify systemic problems. It publishes reports and blog posts flagging cases where the IRS is applying rules incorrectly, or where relief that legally exists is not being made accessible to taxpayers. The third thing is it publishes specific guidance on how taxpayers can protect their rights in evolving legal situations, exactly as it did with the COVID-era penalty refund case. And the fourth thing is it gives Congress the information it needs to fix IRS problems through legislation. Every one of these functions costs you nothing to access. There are 2 ways to reach the Taxpayer Advocate Service. The first is directly. You can call the TAS at 1-877-777-4778. Lines can be busy, so persistence matters. And the more specifically you can describe your hardship or the problem you are trying to resolve, the faster the intake process moves. The second way, and this one surprises people who do not know it exists, is through your congressional office. Your congressperson's office has a staff member specifically designated to help constituents who are having problems with federal agencies, including the IRS. You call your representative's local district office, explain that you have a tax problem that the IRS has not resolved despite your attempts, and ask them to contact the TAS on your behalf. Congressional offices have established relationships with TAS and can often accelerate the process significantly. You do not need to have supported your representative politically. You do not need to donate to their campaign, and you do not need a particular level of income or circumstance. You are a constituent. That is the qualification. This route to the TAS is one of the most underused and most effective tools available to ordinary citizens navigating a federal agency that is not responding to normal contact attempts. The second tool is a form called Form 843, officially titled Claim for Refund and Request for Abatement. This form exists specifically so that taxpayers can formally request that the IRS refund a penalty or abate it, meaning reduce or eliminate it, when they believe the penalty was assessed in error, or when they have reasonable cause for the behavior that triggered the penalty. Let me explain what reasonable cause means in the IRS's own framework, because this is not a vague concept. The IRS defines reasonable cause as situations where the taxpayer exercised ordinary business care and prudence, but was still unable to comply with the tax obligation. The most common grounds that qualify are: you relied on incorrect advice from a tax professional, you had a serious illness or medical emergency, you had a natural disaster or casualty that affected your ability to comply, you received incorrect information from the IRS itself, or you were otherwise unable to act due to circumstances genuinely beyond your control. These are not loopholes, they are the official IRS criteria, published in IRS Publication 594, for when a penalty may be abated. Form 843 is how you formally invoke those criteria. You complete the form, describe the facts of your situation in the explanation section, reference the specific penalty you are contesting, and send it by certified mail with return receipt. The form itself is free to download at irs.gov. The mailing costs a few dollars. There is no fee to file it. What you receive in response may be a denial, a partial abatement, or a full abatement, but you are allowed to ask. The default outcome if you do not file is that the penalty stands. The outcome if you do file is that it might not. The third tool is your own IRS account transcript, (ARS), a record of every transaction on your tax account going back years. Most people have never pulled one. They do not know they can, and they do not know what to look for if they did. Here is how to access yours. Go to irs.gov, click on Get Your Tax Record, log in to your IRS account, or create one if you do not have one. Navigate to View Tax Records and select the tax year you want to review. Your account transcript will show every transaction, every payment, every refund, every penalty assessed, every interest charge, along with a 3-digit transaction code that identifies what each entry is. The 4 transaction codes most relevant to penalty review are TC166, which is a late filing penalty, TC276, which is a late payment penalty, TC196, which is interest assessed, and TC176, which is an underpayment of estimated tax penalty. If you see any of these on your transcript and you believe the underlying penalty was assessed in error, or if you have reasonable cause that you have never formally submitted to the IRS, those entries are the starting point for a Form 843 filing. The transcript tells you what was assessed and in which tax year. Form 843 is how you contest it. The TAS is who you call if the process gets stuck. Let me close with what I think is the most important thing in this entire video. Not a form number or a phone number, but a shift in how you think about your relationship with the IRS. For most people, an IRS penalty notice is the end of the conversation. They open the letter, they feel the anxiety, and they either pay what it says, or they put it in a drawer and hope it goes away. Neither of those is the informed response. The informed response is to pull your transcript, understand what was assessed and why, determine whether the facts of your situation support a reasonable cause argument, and decide whether a Form 843 filing makes sense. The IRS resolves millions of penalty abatement requests every year, requests that were filed because taxpayers knew they had the right to ask. The ones who do not know they have the right to ask simply pay. This is the pattern that the National Taxpayer Advocate herself has described as a core problem. When relief exists but is difficult to access, taxpayers without representation lose benefits that the law provides for them. You have representation right now. It is this video, this information, and these 3 free tools. In the next video, we are going to cover the Social Security Overpayment Notice, a different kind of government letter that creates the same kind of anxiety for a completely different set of reasons, and where the same principle applies. You have options the letter does not explain to you. Subscribe if you haven't, hit the bell, and I will see you in the next one.